May it please the Court, I appear for the NPA respondents, the 4th and 7th respondents, together with Mr. Osborne and Mr. Mabuda.
May it please the Court, I appear on behalf of the 3rd respondent, Mr. Nkosana, together with my learned friends, Ms. Griffiths and Ms. Motlasedi.
Justices, may it please the Court, together with Mr. Manensa, I appear on behalf of the Helen Suzman Foundation.
But provide for the filing of written submissions by counsel who would have been appointed by the Johannesburg Bar after today's hearing of the matter on the question of the constitutional validity.
Thank you, my lady. My client has never been a party to that issue, but I know that my learned friend, Mr. Badlander, has considered your ladyship's raising this question.
I intimated when we met.
He proposes to make submissions on that score. May I start off by simply identifying the issues, and those of them that I will address, my learned friend, Mr. Shaskelson, will address, and those that we do not address. There is firstly our submission that the settlement agreement was unlawful. There is nobody before the court today who disputes that proposition, but the High Court's orders on that score are subject to confirmation, and I will accordingly address that issue, albeit briefly. Second issue is that it's submitted on behalf of the NPA that even if the settlement agreement was unlawful, there was nonetheless an extra statutory voluntary resignation. My learned friend, Mr. Shaskelson, will address that point. The third issue is whether Mr. Abrahams should vacate office or be allowed to remain in office. I will submit that he must go. The fourth issue is whether Mr. Nkosana should be reinstated in his position. We will submit that he should be allowed to stay, but we will defer to the argument made on his behalf, which will be the principal argument on that score. The fifth question is whether the High Court was correct in finding that the President Zuma was disqualified from appointing the next NDPP, but that issue has both disappeared because the appeal has been withdrawn and the issue has become moot, so it is simply not before this court. The last issue is the validity of the provisions of the NPA Act under attack by CACHALIA. It will be addressed by CACHALIA, and we will not do so. If I may then deal briefly with our submission that the settlement agreement was unlawful and unconstitutional. And we submit that that was so on two grounds. Firstly, because Mr. Nkosana never requested to go, and secondly, because the compensation offered to him to go was impermissible under Section 12 of the NPA Act. Underlying both submissions is firstly the Constitution, Section 179(4), which this court held in the certification judgment guarantees the independence of the prosecution. That principle is given effect to in the NPA Act in various provisions, including Section 32, But one of those provisions designed to give effect to the independence of the NPA is Section 12, which provides for the security of tenure of the NDPP. The significant provisions of Section 12 are firstly Section 12.5, which provides that the National Director or Deputy National Director shall not be suspended or removed from office except in accordance with the provisions of subsections 6, 7, and 8. So it makes it clear that it is an exhaustive account of the mechanisms by which the NDPP may be, his appointment may be terminated. The next provision is then subsection 8, which makes it clear that the NDPP may be allowed to resign at his request, but that there are jurisdictional requirements for such a termination. The first is that he makes a request. The second is that he furnishes reasons for the request. The third is that the President finds those reasons to be acceptable, deems those reasons to be acceptable. And then the last is that the compensation paid to him pursuant to the termination of his appointment is the compensation prescribed by Section 12.8 C2, which is essentially the prescribed pension and no more. In this case, there may have been debates about other forms of termination, but the President himself has made it clear that he acted under Section 12. He did not at any time advance any other justification for the termination of Mr. Nkosana's appointment. And I'm not going to take you there, but if I can give you the references where he explained that he had acted under Section 12, they are firstly in his reasons, which are at page 460 of the papers, in paragraph
16.
Paragraph 460.
No, page 416?
Sorry, page 460.
460, sorry.
Paragraphs 6 and 7. In his answering affidavit, page 526, paragraph 5.1, and also in his answer, page 527, paragraphs 5.5 to 5.12, and lastly, page 539, paragraph 12.7. And I emphasize paragraph 12.7 because it is the only place you will see when you read these passages that the President essentially said that Mr. Nkosana asked him, requested his permission for Mr. Nkosana to resign, that this happened in a one-to-one exchange between the two of them, and the most accurate dating, he doesn't say when or where that conversation took place, the most accurate time period that he puts on it is in that last reference, paragraph 12.7, where he says that it occurred, and I quote, during the end of 2014 and the beginning of 2015. That is as accurate as it gets. Now,
Mr. Trengoof, your 10 minutes protection has expired.
thank you, my lady. Now, Mr. Nkosana, the President's explanation that Mr. Nkosana requested his permission to go during that period from the end of 2004 to the beginning of 2005 is simply incompatible and irreconcilable with the documentary evidence before the court of the exchanges between the parties. And let me say two things about those documents. The first is...
Just before you get into much detail on that, let's start with the statutory provision, which is your springboard. Section 12.5. The National Director and the others shall not be suspended or removed from office. And one knows that the request to leave is not a suspension, is not a removal. What should one make of that?
Justice Madlanga, with respect, I accept that in the ordinary meaning of suspension or removal will not include resignation on request. But if you have a look at subsection 5, then it says, shall not be suspended or removed from office except in accordance with 6, 7, and 8. And 8 is the termination on request. So
must we read the removal to include self-removal?
Indeed, indeed. Because it would otherwise not make sense for 12.5 to refer to 8 as well. Now,
Mr.
and
Trengrove,
that is what the President says.
Mr. Trengrove, if I may interject, Section 12A,
Section?
Section 12.8 allows the President to permit the NDPP to resign, but at his request. And he must furnish sufficient reasons for his resignation.
Indeed.
There is a letter that was written by Mr. Mabunda on the 10th of December 2014 that Mr. Ngasana had never requested the President to vacate his office as would be required by Section 12.8, subsection 8, Roman figure 2. Rather, the President appears to have asked Mr. Ngasana to vacate his office, to which request Mr. Ngasana had indicated that he would consider only if he was paid out the full remaining term of his contract.
Indeed, milady, that is absolutely so. And that is, there are 6 documents which we would say refute the President's contention that there was a request. But the most important of them is the letter that you identify. And I will refer to all 6 of those documents, but let me just say this of all of them. Firstly, they were documents that the President unlawfully concealed until he was compelled to disclose them. He was obliged in these proceedings by Rule 53 to disclose the record of the administrative action, the decision to allow Mr. Nkasana to resign. He did not disclose any of this correspondence. He had to be, it was only when the applicants learned that this correspondence existed and hadn't been disclosed, learned from Mr. Nkasana, that they brought an application to compel the President to disclose it, which he then did. So the one feature is that the President first tried to conceal this correspondence. But the second is this. The applicants then filed a second supplementary affidavit in which they dealt with this correspondence and its significance. That affidavit starts at page 627, and they dealt with this newly discovered correspondence from page 642 in paragraphs 38 to 40. And then the significant thing, what did the President do when this damning correspondence was produced? The President didn't respond. He filed an affidavit deposed to by the State Attorney, who merely said that he had no knowledge of these matters. So the President never sought to give an innocent explanation for any of this correspondence. And we must therefore accept that the correspondence reflects the true interaction between the parties and not the earlier suggestion of the President that Mr. Nkasana requested to go. The affidavit filed by the State Attorney is at page 725. He deals with this correspondence from page 730 in paragraphs 15 to 22, and you will see that all he says is, I have no knowledge. So the correspondence is crucial. Milady, the letter you identified is the most important of them. They are dealt with in our heads of argument from page...
Would it be correct that that letter was not initially disclosed by the
Indeed.
President?
None of this correspondence was initially disclosed. All of this was disclosed only pursuant to the compelling application. We deal with this correspondence in our heads of argument from page 22, but if I may just briefly identify the 6 most crucial of those documents. And the first, milady, is the one we deal with at page 23.
Very uncharacteristically, Mr. Trengrove, Throughout this morning, you've been referring to my colleague presiding as your lady. I think it's about the 5th time or so now.
I stand chastised, Justice Matlanga and Justice KaMpepe.
It's well taken, Mr. Trenkov.
The first of those documents is then the letter from Mr. Mabunda of 10 December, where he made it quite clear that his client did not request to go. The request came from the President, and Mr. Nkasana's response throughout has been that he was not prepared to go unless he was paid the full salary for the remaining 8 years of his appointment. So it manifests everything except a request to go. If you look at the top of page 24 of our heads of argument, he said, "It has never been the NDPP's intention to resign from his position, since he considers himself to be a fit and proper person." And then we quote lower on the page, "We are advised that during the discussions the NDPP had with the President, the NDPP made it very clear that he will only consider stepping down from the office if he is fully compensated for the remainder of his entire contract," and so on. That is never challenged, never disputed, never explained. The next important document we deal with is over the page, at page 25, in our paragraph 32.11. That was when Ms. Makene from the Presidency responded to the letter and did not in any way dispute the contentions. The third is mentioned in our page 26, paragraph 32.12, Mr. Mabunda's reply to Ms. Makene on 15 January, where he again reiterated, "We further wish to record that our client has at no stage initiated discussions regarding settlement." Ms. Makene's response on 23 January, where she said because the parties had not made sufficient progress, the President had decided to proceed with the inquiry. So he was pulling out the stick again when the carrot didn't work. And then over the page, on page 27, in paragraph 32.17, we referred to the settlement offers made by Mr. Hully, which ultimately led to the settlement that was then made. And there are two of them that are important. The first is the one we mentioned in paragraph 32.17.1. Mr. Hully sent a draft agreement to Mr. Nkasana on 4 March, and it proposed compensation in an amount of 10 million rands. There followed another proposal to the same effect, and then the last document is the one we mentioned in paragraph 32.17.3. Mr. Hully sent a further draft to Mr. Nkasana. This time, the compensation amount in the agreement was left blank, and the covering email said, "Await final amount from you." So what is absolutely clear is that Mr. Nkasana held out throughout the process that he would only agree to resign if he was paid his full compensation. Mr. Hully tried to persuade him.
Is that not an invitation to say, state your price?
Yeah, absolutely. This last Hully email was, "Okay, I give up, you state your price," which he then did, and the settlement was made at 17.3 million rands. So, and then let me just emphasize again, having put up that interpretation of this correspondence, President Zuma does not react. He puts forward an attorney who says, "I have no knowledge." We submit that there is absolutely no room left on the papers, on the evidence, for any suggestion that Mr. Nkasana requested to go. The settlement is secondly unlawful because it paid Mr. Nkasana an amount of 17.3 million rands instead of the pension permissible under section 12.8C2. The section makes it quite clear that when there is a resignation at the request of the NDPP, the NDPP shall be deemed to have been retired in terms of section 16.4 of the Public Service Act, and he shall be entitled to such pension as he or she would have been entitled to under the pension law applicable to him or her if he or she has been so retired. That section 16.4 says that a public servant may retire at age 60 years. So it's the person who reaches the normal retirement age. So what this section says, in effect, is that when an NDPP retires or resigns at his own request, then he may be paid, by leave of the President, then he may be paid the standard prescribed public service pension.
I know, if I may interrupt, Mr. Trenkov, I know this might actually seem quite unfair, but if Section 12, subsection 8A2, read with Section 8C, had been applicable, do we know how much money would Mr. Nkosana have been entitled to regarding her to Section 16, subsection 4 of the Public Service Act?
No. We don't know what the quantum is, but we do know that it would have been the normal pension.
What if the quantum would have been more than 17 million, Mr. Chengrove?
No, nobody has suggested anything of the kind.
Is it your submission that the quantum would have been low?
Indeed.
If
And-
Section
well,
16.4 had been taken into account?
It would have been a pension, and a pension is a monthly emolument for life. So an actuary, I would imagine, could put a value on it. But what it is not is an upfront cash lump sum payment of 17.3 million.
It could
rand.
possibly include a lump sum as well, an initial lump sum followed by monthly payments. We don't know that.
I'd have to check the regulations, but I don't understand that to be so. I understand that to be simply a normal pension paid on retirement. I'm not even sure that there is a standard, because there might be more than one pension fund involved. But Justice John, I speak subject to correction. But we submitted that it is also not a question of more or less. They were not allowed to make a special agreement with him beyond or in other terms than the prescribed terms. So we submit that the settlement agreement was unlawful, unconstitutional, and that the High Court was correct in declaring it to have been so, which means that the orders declaring the settlement agreement to be unlawful and invalid and setting it aside. Secondly, setting aside the termination, declaring the termination of Mr. Nkosana's appointment to be unconstitutional and invalid. The High Court didn't set it aside. I'll come back to it. And the ordering Mr. Nkosana to repay the 17.3 million rand. Those orders we submit with respect were correctly made and should be confirmed.
Mr. Trengo, may I just come back to the quantum? It seems common cause that the amount paid was unlawful. But it seems to me that, subject to submissions from Mr. Chaskelson, that the ordinary remedy for that is to pay the correct amount in terms of 12.8c. And perhaps I should just add, because it deals with the question is relevant to whether the jurisdictional fact for a request was established. In the ordinary cause and the public service, and even in this sort of situation, where, let's assume a president acting bona fide, let's try and wish away some of what's happened here, initiates a conversation with an NDPP and says to the NDPP, look, it seems that there are some difficulties in the employment situation. We don't want to start a whole inquiry against you. But it seems that given the situation that presently exists, is it not an idea for you to consider resigning? And an NDPP, carefully applying his or her mind to that situation, would say, look, I'm also tired of this place. Can I leave? So that would be a process initiated not by the NDPP, but by the President. But ordinarily, it should be quite uncontroversial. And that, on the face of it, then would fall within a request, and the person would ordinarily then be entitled, the NDPP, to what he would be entitled to by law. Nothing more, nothing less. Why is that not the situation here?
Well, let me say, my learned friend, Mr. Shaskelson, will address the suggestion that this was a unilateral resignation outside of the parameters of the Act. But may I just say this, Justice Kachalia, the proposition that the conversation may start with the President and not with the NDPP, I absolutely accept. What the section requires, however, crucial to the section, is that the NDPP ultimately goes because he wants to go, not because he's been bullied to go or because he's been seduced to go. Now, in this case, the President tried both. He first tried to bully him by threatening him with a public inquiry into his fitness to hold office. And when that didn't work, he seduced him by paying him an obscene amount of money. So I entirely accept that I'm not suggesting that that conversation may only start with the NDPP. I entirely accept that there are situations in which a conversation like the one you postulated might persuade the NDPP to ask to go, and that the President then allows him to go and he's paid the pension under the section. That is an innocuous and everyday and a common sense occurrence. But what the constitutional requirement of prosecutorial independence does not permit is that the NDPP is persuaded to go either by unlawful bullying or by unlawful seduction, by paying a large amount of public money. That is where the vice lies in the device that was employed in this case.
But, Mr. Trengo, there's no suggestion by Mr. Nkosana that he was bullied. In fact, on the contrary, he stood his ground.
Absolutely.
So there's no basis in the papers to say that he succumbed, let's call it, to the temptation of a bigger amount because of any duress. The question of duress doesn't arise. So,
well, the President tried. The President tried.
But so he may have tried, he was unsuccessful. That's over because Mr. Nkosana stood his ground. So what is then left only is the price that he was willing to accept when he left.
Well, indeed, he was not, ultimately, the President tried to bully him out of office. He didn't succeed. He then seduced him out of office by paying him an extraordinary amount of money. And in the end, he was unlawfully seduced to leave office. He didn't go because he wanted to go. He was persuaded to go by seduction rather than by bullying. And that is where we
Mr.
submit.
Chengrove, are you saying that in the amicable conversation that Justice Kachalia referred to, the section never allows for an additional amount to be paid to the director, that director is only entitled to his pension? What if the amount is far less than 17 million, or if it's a 500,000 or a million and can be justified in some way where it says we take into account the fact that you won't have certain benefits or medical aid anymore? Are you saying that is never allowed in terms of the section?
We submit in the first place that the section simply doesn't allow it. The section says pension and no more. But what we submit is important, is not the technicality, but the principle, namely that you may not persuade him by money to leave office. So even if there's some room for paying more money for legitimate considerations, that would be a different matter. But what you may never do, because it's unconstitutional to do, is to use public money to seduce him out of office. And that is what the President did in this case.
All right,
In
Mr.
this case,
Trengo.
sorry.
Just help me on the facts. After Mr. Nkosana and the President had agreed the amount, was there any attempt to meet the requirements of the section? Did he write a letter, say, Mr. President, for these reasons, I want you to release me from office?
No. No, there was no pretense at compliance with the section. There were the Hali offers that was accepted finally when Mr. Nkosana could name his price, and that became the settlement agreement. Can I turn
Mr.
to
Trent, before you move, on the facts, where do we find the inducement by the President? I've already referred you to the letter of the 10th of December, 2014. Would one start there in tracing the inducement?
Yes. It is a pattern that is highlighted and started by that first letter, but what the pattern makes clear is the President wants Mr. Nkosana to go. Mr. Nkosana resists and said, I won't go unless you pay me out for the full amount of my contract. That demand is repeated, and it ultimately culminates in the Hali offer, which says, name your price, and he puts in that price. That amount is indeed his salary for the remainder of his term. So that was purely that negotiation. There was nothing more to it. There was no attempt or even pretense at compliance with the section, the request and the pension and so on. Can I turn to the other topic, which is, so we submit that the termination of Mr. Nkosana's appointment was unlawful. The next question is the fate of Mr. Abrahams. It is common cause that I think it is common cause that his appointment was unlawful and unconstitutional because there was no lawful vacancy to which he could be appointed. The only debate is whether this court should, in the exercise of its remedial discretion.
How can that be common cause, though? It's a fact Mr. Nkosana is no longer in office. He has vacated on the terms and on the basis that you have explained, so he is not there. There is nobody occupying the office of NDPP. Why does Kelland and any other similar authority not apply?
No,
there is a vacancy, he is not there.
Well, and I accept that under the Curland principle, one might say he is deemed to have resigned and therefore there is deemed to be a vacancy. But that is not so. Curland only operates until the court then determines the constitutionality and validity of those decisions. So that once the court determines that the termination of Mr. Nkosana's appointment was unlawful and invalid, then the Curland presumption disappears and one is faced with the reality that there was no lawful vacancy on in the office of the NDPP. So, Justice Malanga, I accept that what you describe is quite appropriate and correct under Curland. But
what are the implications and ramifications of the submission you've just made then? So it should mean, of course, I know you will then say under 172, this is what we should do or shouldn't do. Yeah. But effectively, it means everything that Mr. Shaun Abrahams or Advocate Shaun Abrahams did during his incumbency is unlawful, well, effectively, or not.
Let me say, that is why there is a 172, and that is a question that arises whenever the court, for instance, declares a piece of legislation unconstitutional and invalid. It then regulates the impact of that declaration. The consequence would often be, if left unregulated, that it would retrospectively invalidate everything done under the legislation. And that is why the court exercises its remedial discretion not to overturn, in other words, to uphold things done under the legislation. And you will see in this case, the High Court order does so. It says, the mere fact that I have declared Mr. Abrahams' appointment invalid does not affect the validity of anything that he's done in his
Do you have authority for this proposition, Mr. Trenwolf?
For
If
what
so,
purpose?
what? What's your authority for the proposition that there was no vacancy, based on the fact that a court at some point makes a declaration as of that point that this was unlawful? And then, even though as a matter of fact there was actually a vacancy, because of this declaration, there was in fact no vacancy. What authority do you have for that proposition?
Well,
I'm not saying you don't, but please edify me.
no, Justice Madlanga, I accept that I don't know of a court case that has ever considered this particular issue.
Or perhaps you'll say what I would usually moan deep inside me when arguing a point before a judge. When they say, Mr. Madlanga, what's your authority? I would think inside but not say it out loud. Why can't I be the first one to say it?
No, what I certainly don't, it would be presumptuous of me to do. But what I do is to argue on the basis of the general principles this court has accepted on the impact of the unconstitutionality of laws and the exercise of public power. This court held from the early days, adhered to the objective theory of constitutional invalidity, which means that when a court declares a law or administrative action to be unlawful, then unless qualified, that operation is declaratory in nature. It operates retrospectively from the outset. And the law and the administrative action is set aside and is invalidated with full retrospective effect. That is the default rule. It is only under Section 172 that it then has the power, which it frequently exercises, to regulate the impact of its order. But under the doctrine of objective constitutional invalidity, the declaration of invalidity prima facie operates with full retrospective effect. So if you find that the determination of Mr. Ntasana's appointment was unconstitutional and you declare it to be so, then the default position would be that that declaration operates with full retrospective effect, which means that there was no lawful vacancy. And let me also say that the
Sorry, just on that point, Mr. Trengove, would it then be open to us to say that declaration of invalidity of the termination of Mr. Ntasana's tenure, its operation is limited, not to go back to the date on which the decision was taken, which may as well then regulate the later appointment of Mr. Abrahams?
I submit with respect that the court certainly has the power to do so. What we debate today is how that power should be exercised, but I accept that the court has the power to do so. May I add one further aspect, one further leg to that consideration? Remember, I'll deal with it a little more fully shortly, but the unlawfulness of the President's conduct lay in the replacement of the NDPP. What he set out to do is to rid himself of one NDPP and replace himself with another. So the appointment of Mr. Abrahams was part and parcel of the President's plan to replace the NDPP. I'm not saying that he had earmarked Mr. Abrahams and therefore rid himself of Mr. Ntasana in order to appoint Mr. Abrahams. But what is absolutely clear is that he abused his powers to rid himself of the incumbent NDPP to replace him with another, so that both the termination of the one and the appointment of the other was closely related administrative decisions.
Mr. Trengrove, could I ask you, what would the situation be? And I understand that's not the situation as you say it is, but if there is a request to vacate the office, and there is then a payment in excess of what is allowed, a year later, the parties realize that there was a payment in excess, it was a good faith one, and the person who left the office accepts that he was paid too much and he accepts the property. Was that vacation, on your argument, also unlawful?
No. No, I accept that. I accept that if the request was not induced by the unlawful payment, then the request is not contaminated and invalidated by the fact that there was a mistaken amount paid. So, but I do submit that in this case, the request was procured by the unlawful payment.
So if the payment, the unlawful payment, was made in good faith by everybody concerned, do I understand you correctly that in that situation, the vacancy would have occurred right at the start, and the subsequent appointment of anybody else would have been lawful?
No, I accept that. The vice in this case lies in the fact that the agreement to go was procured by the unlawful payment, and that's why the two are tied. But on the facts that you postulate, I accept that a mistaken good faith payment, which departs from the section, doesn't infect and invalidate the agreement to go. Can I say of the excess?
But it seems to me that the facts are slightly different, because the NDPP says, Mr. Nkosana says to the President or the President's team, I've done nothing wrong, I'm not prepared to go. But if you pay me properly, in other words, the full terms of my contract, I will leave. So what he's doing, in fact, is negotiating only about the price. And he says, if you don't meet I'm going, I'll absolutely go, but you must give me the price. So in a sense, it's not the unlawful inducement which precipitates the conversation. It is the unlawful solicitation of an amount.
Justice CACHALIA, with respect, that's simply not the tenor of that exchange. The tenor is not Mr. Nkosana who says to the President, I'm going, let's talk about my price. The tenor is the President says, I want you to go, and he says, I won't go unless you pay me for the full amount of my contract. In fact, that's what the Mabanda letter says, and the subsequent exchanges also say, I won't go unless you pay me for the full amount of my contract. So it is a President seeking to persuade Mr. Nkosana to leave, and ultimately succeeds only by acceding to his insistence that he wouldn't go unless he's paid the full amount of his
In that case, Mr. Tengrove, may the President entice the NDPP to resign by offering him compensation than that provided for in Section 18?
No, with respect,
12(8)(c)?
With respect, Justice Kampepe, he may not do so, and that's the essence of the unlawfulness of his conduct in this case. He offered him an unlawful amount in order to persuade him to go. That's the heart of the unconstitutional abuse of power in this case.
Mr. Trengove, sorry to interrupt. It seems to me, you can correct me, it seems to me that what you're saying is that there was an ulterior motive on the part of the President.
Absolutely.
The High Court found, as I read the judgment, that it couldn't go so far, and that it could only say that the President was reckless. The finding then, as I understand it, it was in good faith, but reckless. But there was no ulterior motive. Isn't that a problem then?
No, with respect, not. The High Court did say that a finding of bad faith beckons, but it settled for the lesser finding. But let me say this. It is immaterial whether the President realized that what he was doing was unconstitutional. But that he knew what he was doing is beyond doubt. What he knew what he was doing was that he was trying to persuade Mr. Nkosana to go. And he knew that what he was doing was to offer Mr. Nkosana increasing amounts of public money in order to persuade him to go. That much the President knew very well. And we submit that that conduct in persuading Mr. Nkosana to go by paying him an exorbitant amount of public money, that is unlawful, whether the President realized it was unlawful or not. So I don't know what legal advice the President had, and he may not have thought about these matters, but he knew exactly what he was doing, and what he was doing was blatantly unconstitutional. May I?
But there is a difference. If he may do something that is completely unconstitutional, but he may do so not for an ulterior purpose. And so, you know, he may well believe that he's entitled to use public funds to get rid of a problem.
Well, no, but that is an
he's
ulterior
obviously
purpose.
mistaken in that. The question is whether he's doing that deliberately and consciously. And that, as my colleague points out, that the High Court shied away from that finding.
No, but what the High Court shied away from is whether the President appreciated that his conduct was unconstitutional. That seems, with respect, not an important question. He acted with an ulterior purpose in the sense that he used public money not to pay a resigning NDPP fair compensation in accordance with the law. He used public money for an ulterior purpose, i.e. the unlawful purpose of persuading him to go. And he is not allowed under the Act to pay him compensation for that purpose. That is an ulterior purpose. So it is immaterial whether the President had good legal advice and realized that what he was doing was unconstitutional. What he manifestly did was to use public money to persuade the NDPP to go because he wanted to replace him. That is unlawful, whether the President realized it or not.
And is it not correct that, in fact, it was the President himself who said, I am acting in terms of Section 12?
And that's exactly what he said. He said it again and again and again. He committed himself. That's ex post facto, of course, but that is so. He doesn't make any other case. Can I come to remedy? The question...
Mr. Trengrove, your time is almost up.
Yes, Justice Kampepe, I've been very acutely aware of it. Let me just do it briefly. On the exercise of the court's remedial discretion, this court said in Allpay 2, that's the remedy judgment in Allpay, reported in 2014, volume 4 SA, page 179, at paragraph 30. Logic, general legal principle, the Constitution, and the binding authority of this court all point to a default position that requires the consequences of invalidity to be corrected or reversed where they can no longer be prevented. So the default position is that the unlawful conduct must be corrected or reversed. It is an approach that accords with the rule of law and the principle of legality. And then paragraph 32, this corrective principle operates at different levels. First, it must be applied to correct the wrongs that led to the declaration of invalidity. The court must set out to correct the wrongs that led to the declaration of invalidity. What is the wrong in this case? May I suggest that there are at least 5 aspects to the wrong committed by the President in this case. Firstly, he abused his powers to rid himself of one NDPP to replace him with another. That's in itself an abuse. Secondly, by doing so, he violated the constitutional requirement of prosecutorial independence enshrined in both the Constitution and in the NPA Act, Section 12 and Section 32(1)(b) of the NPA Act. Thirdly, he unlawfully used public money to have his way. In the fourth place, he did it all for his personal benefit, to minimize the risk of his prosecution. And fifthly, because he did so in his personal interest, he also violated Section 96(2)(b) of the Constitution. It provides that members of the Cabinet, which includes the President, may not act in a way that is inconsistent with their office or expose themselves to a situation involving the risk of conflict between their official responsibilities and their private interests. Those were the aspects of the wrong committed by the President, and that is the wrong that this court said one should endeavor to set aside. The question is, how best does one set aside this, how best does one address this wrong committed by the President? Submit with respect, you cannot address this wrong while leaving the outcome intact. In other words, you cannot address this wrong by allowing Mr. Abrahams to remain in place, because that's exactly what the President sought to do. Any outcome that leaves Mr. Abrahams in office of the NDPP would make a mockery of the Constitution, because it would leave in place exactly the outcome that the President sought to achieve.
But Mr. Trengove, is that correct? He may well have sought, because Mr. Nkasana had become troublesome, he may well have sought to want to remove Mr. Nkasana for a whole range of facts. There's no suggestion that he did it specifically in relation to the problem of his impending prosecution at all.
Well, with the greatest of respect, there is no, that he is accused of acting to protect himself, and he never gives a credible explanation for any other explanation for his conduct. So that we submit with respect that the inference is irresistible that he rid himself of Mr. Nkasana because he was exposed to prosecution himself, and he didn't want Mr. Nkasana to be in charge of that decision.
But isn't the inevitability of that argument that he, whoever he appointed, would have been hit by this argument?
Yes, yes. I'm not suggesting that that Mr. Abrahams should be removed from office for reasons peculiar to him. I know that the High Court said a lot of things about him and his misconduct. That's not the argument I made. The argument I submit with respect is that the President's wrong cannot be addressed while leaving in place the outcome that he sought to achieve. And the question then is, what about Mr. Abrahams? Isn't it unfair to him?
Before you reach Mr. Abrahams, you also made reference to Section 90. In other words, he was, at that point when he appointed Mr. Abrahams, he was conflicted. But that is absolutely true at the time he appointed Mr. Nkasana.
Yes.
There was a pending prosecution.
Yes.
All right, and that appointment was made after Mr. Pikoli was gotten rid of. So we're in exactly the same position. He was conflicted throughout, 10 years perhaps.
That is so, but it doesn't make it any better to keep Mr. Abrahams in place.
No, but the point is directly related to the reinstatement problem. We're not talking about remedial action.
I accept that that is so, but it doesn't cut the other way. It is not a reason to keep Mr. Abrahams in place merely because the appointment of others may have been infected by the same vice. Mr. Abrahams pleads personal interests. Well, I submit that it is, I'm not accusing Mr. Abrahams of complicity in the President's scheme. We simply don't know whether he was complicit on the one hand or a mere pawn in it on the other, but it was the one or the other. And I will accept that he was merely used by the President to achieve the outcome that he sought to achieve, and that is to replace Mr. Nkasana with somebody else.
Mr. Trengove, would I be understanding your argument correctly if I say what you seem to be contending is that permitting Mr. Abrahams to stay would allow the President to achieve through unlawful means that which he had wished to obtain all along, and that is to get rid of Mr. Nkasana?
Absolutely, absolutely, Justice Kompepe. That, so that if the focus is, as the court said it has to be, to correct the President's wrong, forget Mr. Nkasana for the moment, to correct the President's wrong, you can't correct his wrong without undoing what he sought to achieve, and that is to replace Mr. Nkasana with Mr. Abrahams. Mr. Abrahams, argues that this outcome is unfair to him. But whether he was complicit in the president's scheme or merely a pawn of it, he was the beneficiary of the president's abuse of power. He would not have been appointed NDPP but for the president's abuse on this, in the exercise of this power. It was a gratuitous windfall for Mr. Abrahams that he received, even assuming his good faith. It was a gratuitous windfall that he received as a result of the president's abuse of power. And there is no legal or moral claim justifying his insistence that he should be allowed to stay when his very appointment was the product of the president's abuse of power. On the contrary, we would submit with respect that when an NDPP, when a court finds that the appointment of an NDPP was made by the president by the abuse of his own powers, then an NDPP would not want to maintain and retain that appointment, which was brought about only by an unlawful abuse of power. So we submit that the suggestion that it is unfair to Mr. Abrahams to deprive him of this windfall he received only by virtue of the president's abuse is with respect not well-founded. So we submit with respect that there cannot be any other outcome than that Mr. Abrahams must go, because no other outcome would address the wrong committed by the president. The last issue is the reinstatement of Mr. Nkosana. We submit at page 38.
Just before you go to the last issue, on Mr. Abrahams' issue, the NPA papers indicate that Mr. Abraham took this position after there was an acting appointment by a certain Dr. Silas Dramaiter. Does that not make any difference at all?
No,
it is, according to those papers,
no,
not directly inherited from Mr. Nkosana's departure.
Justice DLODLO, they make it in their heads of argument again, and we submit with respect it's a red herring. All it means, if you accept that the termination of Mr. Nkosana's appointment was unlawful and invalid, then there was no vacancy. Then it means that Mr. Ramaite's acting appointment for 18 days was also unlawful. But that is moot, it's history, and it's not before this court. It need not detain us. That appointment would presumably still stand under the Curlin principle, would be deemed to have been a valid appointment. But what is before the court is the subsequent appointment of Mr. Abrahams. Once the court finds that the appointment of the termination of the appointment of Mr. Nkosana was unlawful and invalid, then Mr. Abrahams' appointment was equally unlawful and invalid, unless the court keeps him in place under its remedial discretion. So you're quite correct, they make that submission, but that is a red herring. I do not propose to say anything further about the reinstatement of Mr. Nkosana. We make our submissions at page 38, but I know that Mr. Nkosana is separately represented and their submissions will be devoted entirely to this issue. So because I've overrun my time, Justice Kampepe, I wouldn't say anything more about it. Those are my submissions.
Thank you, Mr. Trencliffe. Well, what the court what the High Court preserved, and we submit properly so,
is the validity of all the decisions taken by Mr. Abrahams in his capacity as NDPP, because one can imagine that it would create havoc in the criminal justice system if those decisions were overturned. And the correction of the wrong committed by the President doesn't require that any of those decisions be revisited.
Yes.
But going forward, there would be no justification to keep Mr. Abrahams in position.
What about the decisions in relation to Mr. Zuma personally? For example, he's already commenced a process. He's given instructions after the decision of the Supreme Court of Appeal. He's run a whole process, and he's on the verge, as we understand publicly, he's on the verge of making that decision. So all of that will be unraveled, possibly.
Well, if he were to do so, we would ask the court's direction, because that's the one issue on which he's been put on warning that he better not take a decision. We submit that it is not appropriate that he should take that decision, and we trust that he won't. Because bear in mind, the decision is also not a binary one, prosecute or not prosecute. What he has done is to appoint a team of, I think, 6 or so people, chaired by a certain DPP of KwaZulu-Natal, and he's acting on their advice. Well, was that an appropriate exercise of his power? Is that term appropriately put together? And then on what charges would President Zuma be charged if he were to be charged? There are a number of components to that decision which ought not to be made by Mr. Abrahams. So we submit with respect, an NDPP other than him should be allowed to consider and take that decision, and if needs be, reevaluate the matter with the benefit of independence. Mr. Abrahams shouldn't do it, and I would imagine, I would hope he wouldn't try to do so.
So that you're fully well aware that the consequence of that may be another delay, perhaps a year, quite easily, because a new NDPP has to be properly appointed. A new NDPP has to familiarize himself or herself with what's happening, start an entirely new process. So that may be one of the consequences, and you say that's an unavoidable consequence.
Well, that's an unavoidable risk, but not an unavoidable consequence. One hopes. I think the High Court gave the President 60 days to make a new appointment. There can be someone in office within 60 days. That person will at least already have a recommendation from a team of prosecutors, and hopefully will be satisfied with the work that they've done, and after familiarizing himself, go with their recommendation or not. But it needn't be more than a few months, rather than to have a tainted decision by Mr. Abrahams, whose appointment is dubious. Yeah.
But if it doesn't do, Section 11 empowers the President to appoint one of the deputies as acting NDPP.
Yeah.
And that person can take whatever decisions
Yeah.
NDPP is entitled to take.
Yes, as long as that appointment is made by the President,
Yes.
and not by Mr. Abrahams, that would be a perfectly acceptable solution. So there are practical ways of overcoming the risk of inordinate delay.
You are aware, you are aware that if we were to reinstate Mr. Nkasana, he would be disqualified from making a decision on the previous president's prosecution. He has filed affidavits in this court calling Mr. Zuma an utter liar. So it's quite clear that he is disqualified whether or not he's reinstated. He's certainly disqualified from making any decision in relation to Mr. Zuma.
Justice CACHALIA, I haven't considered the matter. You may well be correct, but the occurrence of a prosecutor who is disqualified by bias is not an uncommon one, and in that event, his deputy would have to take the decision. So it is not an occurrence which does not occur from time to time.
Thank you, Mr. Tringo.
Thank you, Justice.
Mr. Chasterson, you indicated that you will be about 20 minutes in your address.
I did, Justice Khampepe.
Would you want to be afforded 10 minutes protection time?
Maybe 2 minutes, just to give an outline of where I intend to go, okay. Justice Khampepe. Justices, I will be addressing the argument on behalf of Mr. Abrahams that Mr. Nqasana resigned and that his resignation was an act that legally took effect independent of the invalidity of the settlement agreement. There are really 3 separate topics that I'll address in the context of this argument. The first is to make some general comments on Section 12 of the NPA Act and the independence of the prosecution service. The second will be to address the argument at the level of fact and to show that it breaks down at the level of fact. And the third is briefly to address the argument also at the level of law and to show that it breaks down at the level of law, and in the process to engage with the GEPF Stradom judgment relied upon by Mr. Abrahams. To start then with Section 12. Section 12.5, or Section 12.5 to 8, are there to protect the constitutionally secured independence of the NDPP. So Section 12.5 says the President can't remove the NDPP by any means other than one of 2, really. The first is the strictly regulated misconduct or incapacity procedures in subsections 6 and 7, and the second is the bilateral acceptance of a request made by the NDPP, but subject to the payments of the amounts prescribed in subsection 8 and no more. Now, the entire purpose of Section 12 would be subverted if one could sever the payment from the invalidity of the removal in this case. Because why Section 12.5 says that the only way to remove an NDPP is in terms of subsection 6 to 8 is to prevent the President violating the independence of the NPA by removing an NDPP he doesn't like, and by doing so through means that the Constitution and the Act don't permit. So if the President tries to buy out an NDPP by paying in excess of what Section 12.8 allows, he can't be allowed to achieve his unconstitutional goal. That would subvert the purpose of the section. And that's why the payment and the settlement agreement are inextricably linked together. One cannot say, well, just make him pay back the balance between the Section 12.8 amount and the 17 million. That subverts the purpose of the section. What it does is it allows the President to achieve that which the section is designed to prevent the President from not achieving, to prevent the President from achieving. So that then is the context against which we have to assess the argument of Mr. Abrahams that Mr. Nqasana resigned and that the resignation is legally effective. And this argument breaks down, first of all, at the level of fact, because it's quite clear that there was no independent resignation that can be separated from the unconstitutional inducement of the settlement agreement. If I might use an analogy from labor law, what the President is prevented from doing by Section 5 is removing an NDPP otherwise than in accordance with subsection 6 to 8. What we're dealing with in this case is a constructive removal, to use the analogy from labor law. Mr. Nqasana was prevailed upon to leave office
by the carrot of the settlement payment and the stick of the pending misconduct inquiry. That's not a unilateral resignation from office. That is a constructive removal from office. And a constructive removal from office is as much a removal as an overt removal from office. And if we go back to section 12.5, it says in very clear terms, the national director shall not be removed from office except in accordance with the provisions of subsections 6, 7, and 8. So if we're dealing with a constructive removal, well, that was precluded by section 12.5. If we go to the facts, it's quite clear that we're dealing with a constructive removal. And the first submission I want to make in this regard is that Mr. Abrahams himself can say nothing on the facts, because on his own admission, he has no knowledge of the facts relating to the termination of the appointment of Mr. Nqasana, and he says that at volume 5, 484, paragraph 8. So his case must stand or fall by the version of the President, and it falls for 3 reasons. The first is that, as my learned friend Mr. Trengove has already shown to this court, there was no request from Mr. Nqasana to resign. And Mr. Nqasana repeatedly emphasized that he did not want to resign, and it was the President who wanted him to resign. He didn't want to resign. So if once that is clear, there can be nothing other than a constructive removal. But even if we look at the case that the President tried to make out on the papers, the President's case wasn't that there was any resignation.
Yes, just to enable my colleagues to participate, the 2 minutes has long expired.
Indeed, indeed. I was waiting for. I'm expecting questions at any point now.
You did not expect to get protection more than 2 minutes. You got protection for
I don't
5
expect
minutes.
it. I wasn't expecting it.
Mr. Shaskalson, he says, I will not leave. I will only leave if you give me what I would have been entitled to under my contract, all the way right up to the end of the contract period. Once he is given that, or at least what some tell us is that, and he accepts it, why is it that at that point, at that very point, he is now resigning? I'm not at this. I just want to understand that as a matter of principle, and not so much the question of, but is the payment itself also lawful? At the exact moment when that which he was insisting on is eventually being offered, and he accepts, effectively accepting to vacate office, why at that point is that not a resignation?
Justice Madlanga, it goes back to my earlier submissions about the purpose of Section 12.5 in particular, and the notion of a constructive removal. Because what 12.5 says is the only way an NDPP can be removed from office is either through these very closely monitored procedures relating to misconduct and incapacity in 6 and 7, or through a bilateral arrangement which is subject to the limited payments allowed in Section 12.8. Once one procures the departure from office by paying more than 12.8, in circumstances where the NDPP has said explicitly in paragraph 3.1 of that letter of 10 December, it has never been the NDPP's intention to resign from his position, since he considers himself a fit and proper person. So once one gets over that problem by paying more, then what is being done is a constructive removal from office. What the President is doing is constructively is effectively circumventing the problem of Section 12.8, or 12.5 in particular. Paying Nqasana more than the section allows, because Nqasana says, I do not want to resign. I regard myself as someone fit. I won't resign. If you want to get rid of me, the only way you can get rid of me is by paying me the full term of my contract.
Even at the stage when I decide to leave, I'm still not resigning. You, President, are the one getting rid of me. Is that the submission?
That is the submission, that there is a bilateral act embodied in that agreement, but the bilateral act is unlawful and unconstitutional because it's a bilateral act that goes beyond the terms that are allowed by Section 12.8 and therefore is inconsistent with Section 12.5. And one cannot separate the payment side of it from the removal side of it because that would subvert the purpose of 12.5. 12.5 is there to prevent the President from buying out the NDPP.
That last submission, to my mind, though, goes more to the question whether this would be leaving or vacating office under Section 12.8, and not so much the other question, are you able to vacate office at all outside of Section 12?
Well, my submission, and that gets to the legal question.
I know, of course, on the facts you will say, the question of vacating outside of 12 is not supported by the facts. But I just want to understand the matter of principle, vacating outside of Section 12. Is that a legal possibility at all? And to what extent does the decision, the SCA decision in Stratham apply or does not apply, and why?
Well, my submission is that Stratham, and I want to preface it by saying that our facts are very, very different to Stratham, and that even if hypothetically it would be possible unilaterally for the NDPP to resign, that's not what happened in this case. But addressing simply the legal question, is it possible for a resignation to take place outside the terms of Section 12? My submission is no, it's not. And I would adopt the reasoning of the High Court in paragraphs 102 to 104 of the judgment, where Stratham is distinguished. And Stratham is distinguished by, the reference is volume 15. I've lost my page reference, unfortunately. I'll come to I'll find the page reference, but it's paragraphs 102 to 104. And there the High Court, in distinguishing Stratham, said the following: in our view, the essential points of distinction between that case and this are the differences in the two legislative backgrounds and the current legislative milieu. We refer here first to the entitlement of magistrates to have resigned under the previous legislative regime and the general approach to interpretation that requires explicit language before taking away rights previously conferred. So to interpret the Magistrates Act not to allow magistrates to resign would have been to interpret it tacitly to remove rights that were previously there. Second, and perhaps more important, says the High Court, we refer to the current legislative milieu and the paramount position that the prosecutorial authority and prosecutorial independence assumes in our constitutional arrangement. It would be surprising if, given this context, a unilateral resignation with no need for approval were permissible despite the clearly higher bar of a request to vacate, coupled with expressed reasons that are reasonably deemed by the President to be sufficient.
Mr. Chesterton, may I ask you? Oh, sorry. I have difficulty in understanding the logic. Why would the NDPP not be allowed to resign? One day he says, this is too much for me, for whatever reason, I'm leaving. I'm not asking for any pension or benefit under Section 12, I'm leaving. And he goes. You say that's legally not possible. I want to know why not. How does that affect the independence of the institution?
Well, there are really two answers, Justice Froneman. The first is that the whole scheme is structured to provide for a system of transparency that everybody knows that this is going to be a genuinely voluntary resignation and it's not the executive getting rid of an unruly NDPP. So that's the logic that underlies it all. And the system of a request with reasons that must be motivated and accepted serves that purpose. But your question to me postulates that it would be unfair on the NDPP not to allow him to do that. But the answer to that concern, if I'm correctly anticipating that concern, is that the President's failure to accept an NDPP's request to vacate office would be justiciable. The President can't capriciously say, no, you can't go. So it would only be in extremely rare cases that an NDPP with legitimate reasons for wanting to leave office would have to stay in office and would probably only have to stay in office for a very short while. In any other circumstance, the President would have no good reason to refuse the request.
But that's not answering with respect, Mr. Chaskerson, the point of principle that my colleague Froneman puts to you. Why, if a person walks into a job and after 3 months says, I actually didn't realize what I'm getting myself into. I'm resigning unilaterally, I'm out of here. And I'm out of here whether the President likes it or not. I'm not making any request, I'm resigning. Unilateral resignation. Why can't that happen?
If I may take on to what my brother says, how does the unilateral resignation of the NDPP affect the prosecutorial independence of the NPA?
To answer both questions, the scheme of 12.8 is to have a prescribed procedure which will provide for a measure of transparency that will give public comfort that this is a genuine unilateral resignation. And that because there has to be a request, there have to be reasons, and there has to be acceptance. And that process can be scrutinized. And that gives the public much more protection in relation to securing the independence, or that the independence of the NPA is publicly seen, than a system of unilateral resignation subject to no scrutiny or process at all. Because the possibility to prevail on someone, to pressurize someone to resign, is much less if you don't have to have a process that provides for reasons to be put forward, reasons to be assessed, and an independent request to have come in the first place. It is a safeguard about the appearance of independence.
So it is your submission that he cannot unilaterally resign after 2 months and walk away?
He can't walk away. He can make a request. If the President refuses the request, the President will have a relatively high bar of justifying the refusal if the request is a bona fide request.
I take you back, Mr. Chaskerson, to Straydom. And you agree with the High Court's bases of distinction, of which there are two.
Magistrates. Can I add a third before you put your question to me, Justice Madlanga?
Perhaps before the addition, let's deal with the two. Okay. You said magistrates could resign, and the Magistrates Act could not be taken to have taken that away. Does that mean that prosecutors could not resign?
No, it means that the distinction is there was no national head of the prosecutorial service before this act.
But that doesn't address the point of principle, though. I don't quite get that.
No, with respect, there is a distinction, Justice Madlanga, because this office, which comes with a duty, is an office that was created for the first time by this act in accordance with the requirements of the Constitution.
But then at the same time, if you recall why the Magistrate Act itself was introduced, it was exactly to give magistrates the independence required of the judiciary, which previously they did not have. They were directly under the Department of Justice, and their situation was lacking of the required independence. So in that sense, the two acts are quite comparable, including even the section that was applicable in Straydom and Section 12 here.
Justice Madlanga, because the magistrates to which this new act applied were magistrates who held office before that act took effect. And those magistrates had been holding office subject to a right of resignation. And the reasoning of the High Court in this regard, and indeed if one goes to the Strydom case, there is, the SCA in the Strydom case makes the point that magistrates to whom this Act now applies had previously had a right of resignation. And that's why one wouldn't want to interpret the Act to take away a right that they previously had. There was never an NDPP prior to this Act. So the first appointee to that position was taking up an office that came with a very specific duty that had never previously existed. And if he or she took that office on whatever terms were applicable to it, if a right of resignation from that office, a right of unilateral resignation from that office wasn't part of the office, well, there would be no retrospective interference with rights.
Magistrate before, you would have said that then the situation is exactly the same, and if Strydom had still been decided the same way, you would have then accepted that Strydom is on all fours or not?
Well, no. Well, that comes to the third distinction that I would add, which is that magistrates are appointed for an indefinite term. Magistrates are not appointed for a fixed term appointment like the NPA. The NPA is appointed for a 10-year fixed appointment in terms of the Act. So any unilateral resignation that is not accepted is automatically a breach of the contract of appointment of the NPA. That's not true of a magistrate's resignation on notice.
Let's deal with the second point of distinction, the one that talks about the paramount importance of the prosecutorial function. What does that make of what I would have thought is the paramount importance of the independence of the magistracy? Why isn't that comparable?
Well, Justice Matlanga, it's not identical because we're dealing with a different situation. We're dealing with the head of the prosecution service and not the head of the judiciary. I mean, that would be the analogy. Obviously, magistrates must be independent. But as this court held in Van Rooyen, that the measure of independence that one requires of magistrates is different from the measure of independence that one requires from High Court judges. And here we're not talking about all prosecutors. We're talking about one person who is the head of the prosecution service, who has very, very specific requirements of independence that flow from the Constitution. And so my submission is that there is a difference. The analogy would be the Chief Justice and the head of the prosecution service. But I do want to come back. Well, to the extent that he has a contract of employment, his relationship with his employer would be regulated by the contract of employment, but subject, of course, to the Act, because any provision of the contract that's inconsistent with the Act would be unlawful.
Yes. But if that is so, why then can't he terminate that contract of employment, which is regulated by the common law, by resigning?
Because his contract is for a fixed term. That's the distinction between him and the magistrate. He may not resign on notice. He has committed with a concomitant duty to be in NDPP for 10 years. That is what the Act provides. It requires a fixed term appointment for 10 years. There's no flexibility there.
No, but I don't understand that. Doesn't the common law apply to fixed term contracts?
One cannot terminate on notice lawfully under common law if one has a fixed term contract. If one commits to a 2-year contract, one commits to serve out the 2-year contract. The common law won't make an order of specific performance to force you to work out your 2 years. But when you terminate before 2 years, unless there's a provision of your contract that allows you to terminate on notice before, then you are in breach of the contract. You have committed for 2 years. In this case, you have a statute which says the commitment is for 10 years and doesn't provide for any notice otherwise than in accordance with 12.8. It says
Yes,
your commitment is 10 years. If you want to leave, the way you leave is you make a request to the President. You motivate it. The President may then accept it, and unless he has no good reason to accept it, he must accept it, and you go that way.
Mr. Chaskelson, if we explore your example of the common law contract for 2 years, if there's a fixed contract for 2 years, surely the employer and the employee can agree that despite the contract that we have, we can agree on a termination.
Indeed, Justice Turon, but in this case, such an agreement would have to be subject to 12.8 because there is a statute that regulates how a bilateral agreement to leave at the instance of the NDPP must take place, and that's subject to 12.8, which is there must be a request, there must be reasons, and most importantly, you may be paid out only that which 12.8 prescribes. So you can't be bought out of office.
Does 12.8 say that you can only be paid out that?
Well, 5 says you...
Or can it be read as that is the minimum to which you would be entitled?
My submission on 12.8 is read in its context. It should be interpreted to provide that this is what you get, no more, no less. If it is just the minimum, then one runs the risk of a payment designed to induce the NDPP to get out of office being accommodated by the section, and that's the very purpose that subsection 5 is designed to prevent. So as soon as one treats 8 as providing a floor as opposed to the required amount, one starts to run into problems with the purpose of protecting independence. But I just want to come back to the submission of fact that I made prior to these legal submissions, because we are not dealing in this case with a unilateral resignation. And it may be quite useful to look at by way of contrast, what happened in Stradom's case. Stradom wrote a letter to the Chief Magistrate and said, "Dear sir, I give you notice of my resignation with effect from such and such a date." It was a unilateral resignation. This is not a unilateral resignation at all. On the contrary, this is a situation where the party who Mr. Abrahams says resigned actually went on record saying, "It has never been my intention to resign. I believe I'm fit and proper. I don't want to resign." And what then happened was an inducement in excess of that which Section 12.8 allows was paid to procure the removal of office of Mr. Ngasana. And so that's why my submission is this should be characterized as a constructive removal from office and therefore inconsistent with subsection 5.
There's no suggestion in the papers, even in the affidavit from Mr. Ngasana that was not allowed, that but for the payment, I would not have resigned. But for the unlawful inducement, I would not have resigned. Or I was constructively dismissed and had no option but to take the payment. That's singularly missing.
No, with respect, Justice CACHALIA, it's not. It's there in the letter of 10 December. Paragraph 3.1 says, "It has never been the NDPP's intention to resign from his position, since he considers himself to be a fit and proper person to hold this position." And paragraph 7 then says, "We are advised that during the discussions the NDPP had with the President, the NDP made it very clear that he will only consider stepping down from office if he's fully compensated for the remainder of his entire contract as head of NPA."
Exactly. So what he then did was he fully considered his position, and He left open-eyed. That's the point. I mean, that he's not in a situation of it's not analogous to a constructive dismissal.
Well, I'm not suggesting it's a constructive dismissal. I'm submitting it's a constructive removal inconsistent with Section 12.5. Because 12.5 says you want to get rid of the NPA, you can do that consensually, but subject only to the payments of the amounts in 12.8. That's the only way you do it. And it clearly treats consensual bilateral removal under 12.8 as a species of removal, because it says you can't remove otherwise than in accordance with 6 to 8. So that 12.8 process is removal, and it says the only way you can remove is in terms of 8. And what we see in that letter is Mr. Ngasana effectively saying, although he may not have been aware of it at the time, and the President may not have been aware of it at the time, I don't want to resign. If you want to remove me, you'll have to remove me in a manner inconsistent with Section 12.8.
Sorry, excuse me. Does 12.8.2 provide for a consensual arrangement to resign?
12.8A2,
Yes.
Justice Gillard?
2, would that allow a consensual arrangement?
Well, there must be some sort of reason, but it may be, I mean, to take Justice Cachalia's suggestion, an NPA who 3 months in says, I didn't have the faintest idea of the stresses of this job, I don't like it, please let me go. That may be sufficient reason for the President to say, I regret this, but if you're not up to this job, or this job isn't what you thought it was, I agree, you may go. I don't want an unhappy NDPP at the head of my NPA. So that would be a consensual removal, but there has to be some bilateral agreement between the NDPP who makes the request in the first place and the President who accepts the request.
Such as the President to acceding my request by paying me what I demand before I leave?
No, that cannot be allowed because the remaining provisions of 12.8 sub C say this is what you get if you go. So it would be to make a request, I want to go because I want to get 17 million rands tomorrow, would not be a request, a reason that could be accepted under 12.8.
Mr. Joskelson, it seems perspicuous from the letter written by Mr. Mabunda on the 10th of December 2014 that Mr. Ngasana had never requested the President to vacate his office, as would be required by Section 12, subsection 8A2.
Indeed. Indeed. I mean, he makes it absolutely clear that he didn't ask for the request came the other way around, and that he didn't want, it's not just that he didn't make the request, it's that he didn't want to resign.
And that would make this to be a situation not of a unilateral resignation.
That would be my submission. It would be a removal procured by a payment other than that allowed by Section 12.8.
And that would distinguish this case from Straydom?
Completely, Justice Kampepe, because Straydom concerned a very clear unilateral request, not request, a unilateral resignation, a unilateral act by the magistrate. I'm resigning. I'm giving you my notice. I will leave office on the 31st of March, or whichever date was given. And unless there are further questions, those would be my submissions in relation to the resignation removal point.
Thank you, Mr. Joskelson.
Thank you, Justice Kampepe.
Mr. Butlender, the court is inclined to adjourn for 15 minutes.
Thank you, Justice Kampepe.
The court is adjourned.
Yeah.